Vice Chair Hernandez.
Thank you, Mr. Chairman. Thank you, Representative Spiller. I had a few more clarifying questions from Representative Raymond's questioning. You said it's worded as may for constitutionality issues and giving law enforcement options. So are we concerned about lawsuits and perhaps violation of not only the federal laws, but our Texas Constitution as well, specifically Article 1, Section 20, which states, no person shall be transported out of the state for any offense committed within the state.
Okay.
Is that what your concern is?
Okay, well, let's go back. I'm not saying anything under our state law. They're not transported out of the state. They're taken to a U.S. port of entry, and they are ordered to go back. They can either choose to go back or not choose to go back. Is the peace officer making that order? What's that?
Is the peace officer making that order in the law?
Yes.
So we're ordering them?
They're ordered to go back.
Okay.
They can choose to go back or not go back, but they're ordered to go back at a U.S. port of entry. This bill has nothing to do.
The bill talks about removal, though. It doesn't talk about taking, says
No.
maybe remove a person
I think they're
in lieu of
ordered,
arrest.
ordering the person to return to the foreign nation from which the person entered or attempted to enter. So
How is that not
it's
removal?
different. It's styled after the removal statute that's in the federal statute under 8 U.S.C., but it's not a formal removal as what the federal government has. They are ordered to return.
Okay.
The
But we're doing the same thing. You're saying in lieu of arrest, we're taking you back.
Well, I don't think it is the same thing, because one, they have a choice. Under a removal, under federal law, they don't have a choice. They are removed. The federal law enforcement will remove them, period. That is going to happen. Under this scenario, they are ordered to leave, but it's not a formal removal under federal law, and it's not a formal removal even under state law. They're ordered to leave, to return. They can either do that or not do that. If they do that, then they go back, and the end of story. If they don't do that, then they can be prosecuted. They can be prosecuted for the removal. They could be prosecuted just if for whatever reason, law enforcement gives the option that they may say, look, we don't really want to charge them with the other offense as far as refusing to comply with the order to return. We may just want to charge them with illegal entry, which is the Class B misdemeanor. I can't really say under what circumstance they would want to do that, but at least law enforcement has that authority.
To say a law enforcement officer wouldn't be transporting an individual, let's say, into Mexico, right?
What's that? Run that
A law
one.
enforcement officer, if they detain someone, they wouldn't be transporting them to Mexico.
They're not,
Just take them
no.
to the border. So the effect would be the same.
Well, if someone goes across, the end result is the same. They're back in Mexico. But it's a different process because one, under a removal under federal law, is going to happen and federal law enforcement does that. Here, again, someone can either go back or not go back. That's their choice. If they go back, then there are consequences for that. If they don't go back, then there are consequences for that as well. But they have a choice whether they comply with that order.
Explain to me, the removal order within your bill, what does that entail? If you're saying it's different from the federal process.
Well, the removal is under 8 U.S.C. 1231.
But that's federal law, so.
That's
our
federal law.
Texas law enforcement officers are making a federal law order?
No. It's not a formal removal. Again, under that statute, it is an order to return. That's different than a federal removal order. Under federal statutes, under immigration law, a removal order is a completely different thing. And there are guidelines under 1231 that provide for that and other statutes as well. But here, it's just an order to return. It's a simple thing, an order to return. It's not in conflict with the removal. It's not a removal. We're not removing anyone. If we, as the state of Texas, were actually removing someone, in my view, that would not be proper. That's not what we need to do because that could be construed in violation of federal law and in conflict with federal law. But
We're just
here,
issuing these orders, but not doing anything.
what's that?
You're saying we're just issuing these removal orders, but we're not doing anything?
We're ordering them back.
But we're not going to transport?
We're not, we will respond. I anticipate that law enforcement will respond whether they comply with that order and return or if they don't. But it's not a removal. It's an order to return.
And my next question is, how will these law enforcement make a determination of who has lawful presence? For instance, I see here,
I think they would
the
do it
bottom of
based.
page 1, it's an affirmative defense to prosecution. Affirmative defense to prosecution, so you're being prosecuted already, if you're a DACA. So these DACA young adults are going to be arrested, and then they
No.
will have a defense
They're
prosecution.
going to be detained, which is completely legal. They're not arrested, they're detained. And, but yes, if they are criminally charged, it's an affirmative defense that they could raise that, hey, wait a minute, we're not entitled to be charged because we raised one of these affirmative defenses.
And all this
that
is going to happen on the side of the road?
What's that?
All this is going to happen on the side of the road?
I doubt it. No.
So they're gonna
But
take it in.
but I think, typically when you raise affirmative defenses in a criminal case, it's after the case is actually filed and you go through that process. Here, if there's some way to determine and identify these folks, if they're here under DACA, that is probably readily known and available, that information. So it's a different situation. That's why I'm saying it.
How is that readily?
They may have that documented. I don't know. I haven't seen any DACA documentation from anybody, so I can't really speak to that.
All these law enforcement officers are supposed to know this whenever they...
No, I don't know if they have any documentation on them or not. Technically, under federal law, when you come over and you're an alien, as that term is defined under federal law, you have 30 days to register, and you're required under federal law to have that paperwork and that documentation on you. This is not the Arizona case. That's what they got into. This is not that at all. But technically, they are required to have that documentation on them if they're here as aliens until they're U.S. citizens.
I mean, I guess as U.S. citizens, we are required to have our driver's license as well, but there are times that I think everybody at this dais has forgotten their driver's license at home. And so my concern is when you're on the side of the road, I mean, how many resources are going to be used for individuals that do have lawful presence here? And what this is providing for is an affirmative defense, but as you said, that's after they've already been taken in.
And I think the whole purpose is to exclude anyone that would otherwise, so as not to conflict with federal law. The entire purpose is to exclude from prosecution or any unintended results, to make sure that people that are otherwise here, whether they're legally granted authority to be here, whether they've been granted asylum, whether they're DACA recipients within the timeframes of DACA when it was created and when it was stopped, any of those things. And I trust law enforcement to look into the totality of the circumstances and make that decision, whether it's on the side of the road or wherever it may be. They make those decisions all the time about whether to detain someone or not detain someone. And so I think certainly that this gives them the leeway and the ability to make those decisions.
You mentioned law enforcement, and that the way the bill is languaged, you include peace officers, and that's a very long list of peace officers within the state. For example, including the officers commissioned by the State Board of Dental Examiners, investigators employed by Texas Racing Commission. Do you envision them being involved in the enforcement? I
don't anticipate any scenario where the State Board of Dental Examiners would be detaining anyone for illegal entry. I can't really see that, but all law enforcement is provided the same protections here, and so they're listed accordingly. Likewise, I don't think the Board of Managers of the Dallas County Hospital District would be involved either. But
then
this covers all,
because
they're all defined as peace officers under the Code of Criminal Procedure under 2.12. So that's why they're listed. They're all entitled to the same protection. I would imagine in the application of this that most of these instances and encounters would happen within 100 miles of the border. I don't anticipate this, and we've talked about this. I don't anticipate this happening in other parts of the state necessarily. I'm not saying it couldn't, but you run into a proof problem to determine when someone actually, when they actually crossed, because this is still a misdemeanor, okay? So all misdemeanors have a 2-year statute of limitations period. If someone is here, and this is what Arizona got into, where Arizona law, the problem was, it was just they were picking folks up or the application would be at any time if they're here illegally. Well, that's not what this bill does. It is set at a definite time, and it's not like the bill that you heard the other day, where the second component of that, as is under 1325, is if you're ever even here illegally or improperly. That's the concern with that bill. This bill doesn't have that. The trigger mechanism.
But page 3 at the top, it says, at any time found in the state. So
Were
that
you-
is
were you looking?
statewide anytime.
Were you looking?
The top of page 3, line 1 and
That's
2. Illegal reentry.
For reentry, yes. I'm talking about the original charge on illegal entry. Reentry is a different deal. Reentry is an entirely different deal. But for
So
entry.
it is statewide and anywhere in the state.
Yeah, it's still a statewide offense. This is not one of these where we're trying to limit it to an on-view offense of somebody actually crossing the river. That's not what this bill does. But, law enforcement can make that determination whether they believe. I mean, let's be realistic. Someone's charged with burglary of a building. Okay, well, the odds are law enforcement didn't see anybody burglarize the building. The odds are that they got information, they followed up on it, they interviewed people, they got statements, they did other things, and they came to a clear understanding of this defendant burglarized the building. They didn't see it, but they know that it happens. By the same token here, they can still charge someone. We do it all the time. We charge people and sometimes convict people for crimes that law enforcement does not actually on view observe. It's not like a DWI that they pull someone over at the side of the road.
How are they going to know that? Let's say someone's at the grocery store. How are they going to know that someone has re-entered?
Well, again, that's a proof
in a store
problem.
in Dallas.
Because if they charge them with this offense, the burden of proof is still on the state to prove each and every element of the offense beyond a reasonable doubt.
How's a law enforcement officer going to decide that? How is a law enforcement officer going to decide that? How they're going to enforce this bill?
Well, I think through law enforcement, through the officers, they're trained. That's why we've got certified peace
Is there
officers that are
training
listed here.
included in the bill?
There will be training. I can't imagine there not be.
Is that
There'll be.
included?
That's not this bill. But I can't imagine that they would pass this bill and then not be implemented without some instruction and training to law enforcement officers. Simply because, if nothing else, it's a slightly different approach than any that we've ever had or any that I've ever seen. So I think certainly there would be training, but no, law enforcement officers are used to looking at the totality of the circumstances to determine who they're going to charge and what they're going to charge them with and why. And so I trust them to make those determinations.
Thank you.